Hi everyone, my name is Raylan Pickup and I am the Attorney General for the 2024 Colorado Youth in Government Conference. So, an Attorney General represents the state of Colorado in legal matters as well as is the main point of contact between the executive branch and the judicial branch. The Attorney General can also make recommendations to the governor regarding legal issues. But besides being an Attorney General for this year, I also won state in tennis. I won fifth place in opening statements at mock trial state. I also competed at nationals for speech and debate, and I have been in Girl Scouts since I was in kindergarten. So I am so excited to get to know and work with each and every one of you. And if you need any help or questions about anything regarding the appellate case, the appellate court, or just being an attorney in general, feel free to reach out to me. So first, what is an appeal? So following a trial, the losing party, or a team that is either a petitioner or respondent, can challenge the result in a higher court. This is done by presenting specific challenges to the rulings of the trial court, such as the exclusion of evidence or to the manner in which the lower court interpreted the law in breaching their results. And these challenges are supported by precedent decisions of other courts in similar cases. In a federal system, a case usually will go from the federal district court to a circuit court of appeals and then to the United States Supreme Court. In an appeal, parties are initially required to file briefs setting forth their arguments and authorities. After the briefs are filed, the parties then present their oral arguments to the appellate court detailing the reasons why their respective clients should prevail. The justices of the appellate court may interrupt the attorneys at any point after the 2-minute grace period and ask questions about their arguments. After the oral arguments, the appellate court will issue its decision, usually accompanied by a written opinion set forth its analysis on the issues. If a particular justice disagrees with the holding of the court, however, he or she may file a dissenting opinion. So for the judicial competition, each attorney team will provide the justices one-page summaries of their oral argument. And teams must consist of 2 delegates as acting as petitioner or respondent. So both attorneys per team must argue, with each attorney speaking for at least 5 minutes. And each attorney may speak only one time during each round. So, for example, if Attorney 1 speaks for 5 minutes of the round and then sits down to allow Attorney 2 to speak, Attorney 2 must complete the round. However, since each team is allotted 20 minutes for their arguments, they may split the time up however they want, but please use all the time and use it wisely. So, what is a bailiff? So, a bailiff is a court official who is responsible for maintaining order and security in the courtroom. They also act as a liaison between the judge, attorneys, or other parties involved in the case. They will keep time for oral arguments. They will hold up signs for the first 2 minutes and when 5 minutes arrives, and then when 1 minute and 30 seconds remained. Before oral arguments, each team will submit to the bailiff or the Chief Justice how the team will split up the time. So in presenting their argument, each side will be given 20 minutes, so please prepare and practice beforehand. I cannot express this enough. Please. Thank you. The petitioner has the right to reserve up to 5 minutes for rebuttal, which is deducted from their 20 minutes total. If a petitioner's duty to announce this before it is the petitioner's duty to announce this before the oral arguments begin. When time is up, it is up to the discretion of the Chief or Associate Justice to allow an attorney to finish their thought or sentence. So, what is an appellate case and how are we doing it this year? So this year, both justices and attorneys will share roles, meaning that attorneys will have the ability to be attorneys and justices and vice versa. So for this year's appellate case, one case will be presented to the Supreme Court. The petitioner team will present first, followed by the respondent. After the respondent's argument, the petitioners have the option to provide a brief rebuttal. And like I said before, each team has a total of 20 minutes to present their argument, so split this up however you want, and please use as much time as you need. Except for the rebuttal, each attorney may go to the podium only one time. So in other words, one attorney of a team gives, let's say, 2 minutes of an argument, then sits down and lets his or her team speak for 5 minutes, and then returns to the podium to conclude the argument, excluding the rebuttal. So during the course of oral arguments, justices may interrupt and ask questions about the argument. Attorneys should answer the justice's questions and then return to the argument. Justices may not ask questions during the first 2 minutes of an attorney's argument, and they may not ask questions during the last minute of an attorney's argument. This allows the attorney to clearly state the purpose of their argument before being interrupted. So attorneys also cannot communicate with their partners while they are presenting their oral arguments. So once an attorney goes to the podium, they must remain there until the conclusion of their argument. Attorneys may take notes, cases, or a summary to the podium, but they cannot communicate with their other teammates. During the oral argument, attorneys should not point or look at the opponents. It's just so disrespectful and informal, and we're not going to do that this year. Oral arguments must be directed at the court. Attorneys should refrain from making any personal remarks about or attacks upon opposing counsel. When a justice begins asking a question, attorneys must stop speaking immediately. It is considered disrespectful for the attorney to attempt to talk over the justice, and if an attorney runs out of time while arguing, they should stop immediately, request permission from the court to conclude the sentence. If the court grants permission to conclude, the attorney must promptly conclude. Pretty simple. So for the one-page summary guidelines, so attorneys must write briefs in order to prepare for their oral argument. This helps justices to plan their questions and understand arguments. So how do we formulate it in the first place? So first, identify the issues. The issue should be a fact-specific statement that poses a question in a light most favorable in your position. So fact-specific means that you state relevant facts from the case with a question of the law. The way you phrase the question suggests a yes or a no answer. So the issue is your opportunity to phrase the question how it benefits you the most. Second, state relevant rules. The rule is a proposed statement of the law that you are arguing applies to the case's facts. With the rule, you are setting up an answer to the issue with a favorable result of your case. Pretty simple. Thirdly, analysis. Very important. Your analysis should be concise and should explain why the rules in the other cases should not apply to your case, or why your case is so different that the rules should not apply. When you do quote or paraphrase from another case, please cite it. And 4, conclusion. In your conclusion, briefly unite once again the case facts and the legal rules. In doing so, you will have argued why the court should rule in your favor. To enhance your argument, you might want to weave in policy considerations as well. Let the court know what impact you envision the outcome having on society. This will grab their attention. Okay, so now we go on to attorney oral arguments. So the oral argument consists of attorneys making arguments of their position in the case of the appellate court. During oral arguments, the attorneys will be interrupted and asked questions by the appellate justices. These questions will help the appellate justices to make a decision on how to rule in the case. The attorneys structure their oral arguments using only the legal precedents to support their case. So, in some cases, both sides of a case may cite the same case to support their opposing arguments, but most cases include a dissent or including legal theory that could be used to support two different arguments if a skilled appeals attorney is able to argue why the case at hand is different from the one decided in a previous case. So, how do we formulate an oral argument? So first you make an introduction. Please start with, "Thank you, Chief Justice, and may it please the court." Then state who you are and what you're going to be talking about. So, for example, my name is blank, and I, with my co-counsel, blank, represent the petitioner or respondent, whichever party you are. And then you cite the basis of the case. So use this time to give an outline of what your argument will be. Try to make it as clear as possible to the justices what issues you will be addressing. Tell what your side believes and why you are right. So begin going into detail of why your side is correct. Use case law and be ready to answer the justices' questions. And end in a conclusion. Having prepared something to say when your time is almost up, make sure to tell the court what you want them to do. So, for example, because of blank, we believe this court should rule blank. Except the bulk of the oral argument is to be devoted to the justice's questions. Use your 2 minutes of interrupted time wisely, please. So, what will happen when you give your oral argument? So, attorneys will enter the courtroom and set up at the counsel tables. There will be someone at the bench keeping time. Each attorney will give the timekeeper and scorekeeper the following information. So, state their name and whether they are the respondent or petitioner. State which speaker they will be. For example, petitioner number 1 or 2 or respondent number 1 or 2. How much time they will need for their presentation. The bailiff will announce the entry of the justices. The timekeeper may also be the bailiff, and the bailiff will say, "All persons having business before the United States Supreme Court are admonished to draw near and give their attention, for the court is now sitting." And the justices will come in and sit down, and the bailiff will state, "Please be seated." And you be seated. Yep. So the first case on the calendar of that blank, they will say that. And then the Chief Justice will ask, "Is the petitioner ready?" And the petitioners will stand. One team member, typically the first speaker, looks directly at the Chief Justice and answers, "Petitioner is ready, Your Honor." And then all the petitioners sit down. Then the Chief Justice will ask the respondents, "Is the respondent ready?" And the respondents will stand, and one team member looks directly at the Chief Justice, like for the petitioners, and they say, "Respondent is ready, Your Honor." And then they also sit down. Then the Chief Justice will instruct the petitioners that they may proceed, and the petitioner, first speaker, will approach the podium and begin. And as soon as petitioner 1 finishes, petitioner 2 will approach and begin their argument. And once petitioners have made their arguments, then the respondents will do the exact same thing. Once both respondents complete their argument, the petitioner The first speaker will approach the podium and make their rebuttal if you have one. Upon the completion of the petitioner's rebuttal, the respondent does not get a rebuttal. The Chief Justice will announce that the justices will retire and make their decision. And as the justices rise to leave, the bailiff will ask everyone in the courtroom to please rise. Once the justices leave, everyone can sit down. So in between appellate hearings, we can be taking breaks so that people have time to review their notes and adjust for the next round. So look out for the appellate case drop for this year, and please don't forget to register. Get on the appellate case as soon as you can so you can prepare early and perform your best at Youth in Government Conference this year. If you are interested at all in the judicial branch, put your top choices as a justice or attorney, because in the end, well, one, you will be both. And two, if you want to go into something in the law field, this is such a good experience for you, and you learn so many new experiences, you meet so many new people, and it's going to be so amazing this year. So if you're interested, please sign up to be an attorney or a justice. Thank you for watching. I know it's really long, but yes, thank you for watching so much. Bye.